Hello, and thank you for choosing the Legacy Lawyers as your source of information. We know this might be a difficult time you're going through, but we are here to educate you and help you through the process. Please stay tuned for our question and answer portion.
Happy Thursday.
Happy Thursday, David. Enjoying your day so far?
I am. What is Thursday? I mean, Monday is Grumpy Monday or Manic Monday, and Wednesday's Hump Day. What does Thursday count for?
Thursday's just that much closer to Friday.
Is it a day? Is it the day of hope and expectation?
It is.
Okay. What about those poor folks who have to work on the weekends?
They're just out of luck.
They're just poor folks.
Yes.
Okay.
Okay, so we're talking about wills and will contests for the next few weeks.
Yes.
So today's question is, what happens if a challenge to a will is successful?
Okay. Well, if the court determines that the contested will is not valid, then if there's any pre-existing documents or prior versions of the will that satisfy the requirements to be a will, those should be submitted to probate. So, for example, if you have an older will and then there's this new will, which is a bad will, then at the time that you're contesting the will, you also need to submit your will into probate. Otherwise, it would go into the default standard rules dividing the estate up, however which way it gets divided. And it also determines with some clarity as to who is going to be personal representative. So, for example, if someone who has a higher level of priority than you submits this bad will, and this will gets invalidated, the court doesn't automatically say, well, okay, whatever prior wills are out there are now blessed if it's not before the court for consideration. So, and also the court may say, well, even though this person did a bad act in getting this will done, that person has a higher level of priority by being the decedent's daughter, as compared to the contestant who is the child of a predeceased child, so therefore the granddaughter. So we're going to appoint this daughter as personal representative. That's not a great situation because this person who just got their will defeated is going to be very upset with you and is not going to administer the estate for the benefit of the contestant with the white glove level of service and care. So you need to have your competing petition, whether for will or for appointment as administrator. And if there's no preceding document, it goes through the laws of intestacy, which is whatever the family relationships are by their proportionate shares. If there's a prior document, they'll roll back to the prior document. And that's what happens.
Okay, thank you very much.
You're welcome.
And if you guys have any additional questions, feel free to email us at smm@thelegacylawyers.com. Have a great day.